Hey guys, well, good morning. And I know that many of you may be surprised me popping on here this morning because I didn't have a chance to fully announce it, but I'm excited because I was able to arrange a time to speak with Adam Holley, who has been working diligently on something very important to all of us here in Oklahoma. It deals with State Question 836 and the challenge to the current primary system that we have. And I know that people in politics, people in the know, have been very concerned about the collection of signatures and the potential change to our primary election system that could result from this State Question 836 proposition. And now it looks like the signatures have indeed been collected. It looks like over and above what was required, 200,000 signatures have been collected. And I've been saying to some of the groups I've been speaking to that I was pretty confident that they were going to get the signatures, as aggressive as they were, and I hate to say it, but as ignorant as the general public is concerning elections and how this is, I believe, falsely being portrayed to the public as a more fair way of doing elections. And, I think capitalizing on the polarization that we're seeing in our public with the extremes on the right and the left, and this call to come to the center and find agreement. That's how this is being presented. This is a way for everyone to come to the center and just focus on the issues. However, what this does is undermines the Republican Party, the reason for parties at all. And we've got a lot of concerns about this. Would, in the end, we have two Democrats as our only choices, just like we saw recently in the Tulsa mayoral race, with a similar process being implemented there. So there's legitimate concerns we have. We're going to talk about all this. We're going to talk about Adam Holley's fight that he's been working on for, I think, over 2 years now. And, he has currently a case, his first one, that has been recognized by the Supreme Court of the United States. I have my very own copy of it right here, and we're going to get into this. He is awaiting a reply from the defendants, and we'll get the details from him in a second. But after this reply, there is a chance that this would be given a date and heard by the Supreme Court of the United States, also dealing with primaries in the nation, really. But there's two cases that he has been working on. One of them is this one I just mentioned that is being considered by the Supreme Court. The other, he just filed a recent appeal here in the Oklahoma Supreme Court, and we're going to get the details on this. But this one deals more directly with State Question 836. And here's the thing. The reason that I'm excited about this conversation is many were hoping and praying that they would not collect the signatures. They would not get the signatures needed to allow this state question to go forward. The signatures have indeed been collected. And now it may just be that Adam Holley's personal fight that he's been working on may be the best hope Oklahoma has for saving the Republican Party here in Oklahoma. So I think it's that important. We're going to get to all of that, so stay tuned.
This is the Jake for the State podcast, and this is the call for every red-blooded, God-fearing, liberty-loving patriot to prepare yourself, take your position, stand your ground, and advance the cause of freedom. Let's go.
All right. We are indeed going to go straight to it. And I have a I want to play a quick clip from some local news that was covering this issue of State Question 836 and the collection of the necessary signatures. So this was from, I think, News 5, and just a good overview of where we stand right now. Let's see if I can hit play here. I may have to go. Here we go.
On Oklahoma Chronicle, we have spent a good amount of time discussing the arguments for and against State Question 836. That's the measure that would put all candidates, regardless of party affiliation, on a single primary ballot, and then all voters would get to choose between them, with the top 2 vote getters moving on to the general election. The big news this week was that the signatures were turned in ahead of the deadline. 173,000 signatures are required to put that measure on a ballot, and organizers say they turned in more than 200,000. The spokesperson with the campaign called the signature gathering efforts Herculean.
They had to collect these signatures over Christmas. They had to do it in a snowstorm. And so, kudos to them on just a great job getting out in the communities across the state, getting these signatures, doing it in the freezing cold, and then, of course, getting them to where we are today.
And you've heard from OKC Mayor David Holt on this very program come out in support of the initiative. He says it would lead to more pragmatic political campaigns, better leaders, while voices against it also on this program saying the change would actually restrict voter choice.
If you poll Oklahomans, they talk about the economy and education and public safety and health care. That's what the candidates should be talking about. That's what the candidates would be talking about if State Question 836 were to become law.
It severely restricts voters' choices in that November general election. You get 2 people to choose from. And like you said a minute ago, they might both be from the same party. In California, they often are. Sometimes 2 Republicans, sometimes 2 Democrats. Either way, the voter isn't getting a lot to choose from.
So that is the heart of it. There is it's being promoted as something that gives people more choice.
One of the greatest threats to public safety is the out-of-control marijuana industry. When Oklahomans voted to legalize medical marijuana in 2018,
we're getting off track there, Stitt. We're getting off track. Okay, let me come back here to the focus. State question that was from the State of the State yesterday. And I was up there at the Capitol and heard Governor Stitt give his final State of the State address. And that was one of the things he brought up was rolling back medical marijuana, bringing that to the vote of the people. Vote of the people has already happened and people voted it in. I don't expect that there's going to be another vote to get rid of medical marijuana, but we'll see. Right now we're focusing on State Question 836 and this issue in the state now becoming very real as the signatures have been collected, as you just heard from that news broadcast. But someone who has been taking up this fight as on a personal level, and now I believe may just be our best hope to saving the Republican Party and Republican primaries here, is Adam Holley. So I want to bring him to the stage. Adam, welcome, sir.
Thank you for having me this morning, and I appreciate all the viewers that's online. So interested in protecting Oklahoma and our republic.
100%. No, and I appreciate your efforts, Adam. Just as a little background, you actually ran for Senate. You were one of the several candidates who I don't know if there 9 or more.
There's 13 on my ticket for the Republican
13,
Party.
oh, wow. To take Jim Inhofe's seat when he stepped down. And so, of course, Senator Mullins was victorious there. But that was where this all kind of came to the surface for you, was it not?
Yes, sir, that's correct. About 10 days after the primary, I was prompted to go ahead and do more research into primaries. A lot of times when we are focused on the cookie cutter system, get through grade school, get through junior high, can't wait to get out of high school, and they barely touch on the Constitution in high school, just enough to pass the No Child Left Behind Act, right? So as we get out, it's upon we the people to go to constitution.congress.gov and look at the Constitution as it is written on the government website, not as some liberal arts teacher that may have a slanted view. For example, my kids, when they were going through, and this is in a prominent, supposedly a really good school system, and I think they are a good school system, just slightly waning. The understanding my own 2 kids had about the Second Amendment was to protect against your own neighbor. We have to take an active role as parents. It took an hour or 2 of really explaining why the Second Amendment was against a tyrannical government and a government that perverts words to seize more power.
Yeah. Well, I mean, this is the root issue I think we have right now in our society is general ignorance. as we are consumed with entertainment, with social media and sports. Very little attention is given to our Constitution, which is the foundation of our freedom, the foundation that protects our freedom and God-given rights in our country. But it is through understanding the Constitution and our laws that we are able to preserve freedom and actually take up and fight tyranny when it presents itself. And so this is what you have done in this case. You challenged. I want to speak briefly on this case that is now before the Supreme Court of the United States. We don't have to get into all the details of that because I'd like to spend a whole nother segment just diving into it. I want to focus mainly today on State Question 836, which is your second case that you have now filed an appeal on, and we'll get into the details there. But just briefly covering this case that is now being considered by the Supreme Court of the United States, what exactly were you seeking to accomplish after you ran for Senate and you started to consider primaries in general?
The main revelation behind the system that they have created since 1910 has been one that has added additional qualifications for federal offices. The
And that's
Constitution,
important to say that since 1910, that's when the primaries were first instituted.
it was called a presidential preferential primary that began in Oregon and spread like a cancer throughout the constitutional republic of the states that were established at that date.
Okay. And now it's become the norm, widely accepted, and this is how we do our elections now, is we have a primary. And interestingly enough, it's a government funded. It's taxpayer funded for the private parties of the Republican Party and the Democrat Party here in Oklahoma. And we may get into that detail a little bit later, but that is the generally accepted way we do elections across the state and across the nation.
Yeah, and what's exciting is when we get to sit down and do the full segment on the Supreme Court case, it uncovers how we hear a lot in today about non-government organizations. But what if I told you some of the first two non-government organizations were political parties called the Republican Party and the Democrat Party? And there's a legal doctrine that is called out in the Supreme Court case called entwinement, which basically gives non-government organizations state power. Kind of like what the Chevron case not too long ago overthrew, because there were unelected bureaucrats that were creating laws and fines for unlegislated law.
And, I think we have to say this just because people listening may be saying, okay, who is this guy, Adam Holley? Is he even a Republican? Is he fighting to support the Republican Party or undermine it?
Oh, the only one I'm sold out to is Jesus Christ, my Lord and Savior. The next is the Republican Party because what the political beliefs align with is my biblical beliefs. And usually when people disagree with me, it's not, politically, it's because of biblical views.
Mm-hmm. Yeah. And so in this conversation surrounding primaries, it's not about trying to undermine really any party. It's really about the proper way we should be holding elections according to the Constitution. And I love that you have grounded your arguments in the Constitution, which is how you started this conversation. And talk to me briefly about that, about what the Constitution says about elections.
Absolutely. The Constitution itself, just a general base history, a lot of people don't realize a lot of the Constitution was inspired from principles out of Deuteronomy, out of the Holy Bible. Now, there's not a lot of references to God and such like that, but you got to understand where we came from and the principles that help guide a more perfect union. And that's what we strive for, is a more perfect union based on these principles. One of the principles they believed in is when the power of the people have the ultimate say-so and not a government machine, then the people live freely and abundantly as our Creator expected us to be able to do, right? So
Yeah.
one of the things is in Article 1, Section 4, Clause 1, the time, place, and manner of holding elections are prescribed, for the senators and representatives are prescribed to the state. And in this, the only qualification for the House of Representatives is Article 1, Section 2, Clause 2. For a United States Senator is Article 1, Clause 3, Section 3. That's it. Now, whenever primaries came in 1910, what they did is added additional qualifying races in order to eliminate we the people's voice, not only in each party eventually, but also any eligible candidate that could represent us should be on the constitutional ballot or the constitutional election, because the Constitution only recognizes the November election, later backed up with a Congress law the first Tuesday after the first Monday.
Yeah, no, that's something I think that we don't give enough attention to is the election. The only election provided for in the Constitution is the November election. And when we start discussing primaries and the how we should do primaries, the first question is, I guess, should we even have primaries? And how would you respond to that question? Are primaries even necessary?
As a party function, absolutely. And this is one of the things, don't get confused with how I'm saying primaries are not ultimately evil and they should be done away with completely. The
Right.
state should not have a financial interest on which party or the candidate makes it to the ballot. And when the state has a financial interest and media has ties to the state, then like what I experienced in 2022, I was supposed to be on the News on 6 and News on 9 so the state of Oklahoma could see who I was as a first time candidate. But the reality was that whenever they came up with after the fact, when they did their own internal polls, I was supposed to be that sixth podium of the 13 podiums. They made a rule because their internal polls, they changed the goal field for we the people. Now, you'll notice that the candidates that had other state experience, we'll say it that way. I don't want to disparage anybody one way or the other, but you will notice the media will always promote and support people who have been in the system, not the grassroots or we the people that have more of a constitutional background.
Yeah. And at the heart of this conversation is this frustration about the attention that candidates get from media. And are we really getting the best candidate in the end, or pick from the top two best candidates, or are we getting the media's selection and the establishment's recycling of their own? Because I believe, like you, that oftentimes the best candidates are out among the people who have not been in the system for a long period of time, and they can come with fresh eyes, fresh perspectives, oftentimes the perspective that's most closely connected with the will of the people. And that's often what we need, but too often the grassroots candidate is shunned or discounted and not allowed to even present on a stage, like you said. And so in that particular instance, you were not allowed to be on that stage, that interview. And so what did they pick, the top 4 or 5? What happened there?
Yeah, they picked the top 5. They dropped the 6th one because of some arbitrary. I ended up polling on their own internal poll 0.9%. And then they came up with if you didn't make above 1% after the fact. So as a way to drop anybody that had never been in the system yet. Mm-hmm. Or that's the perception. I want to be clear that is the perception when I talk to people that they have the same perception. It's very funny that the top 5 people that were in politics for more than 4 years were the ones that were permitted to be seen and shown to the people.
Yeah. Exactly. So that prompted then you to do your homework. You dug into this, and um, I don't want to spend, like I said, too much time on this Supreme Court one, but give us another quick overview of where that led you when you were digging into primaries, and what led to this case.
Well, a lot of it, whenever I was being revealed the information, there's a really old Supreme Court case. They have been trying to overthrow the constitutional republic from its inception. In 1803, Marbury versus Madison was a very pivotal case where Chief Justice John Marshall had actually ruled that anything repugnant to the Constitution is void from its onset, as well as that the Supreme Court is what can say what is law, not make law through precedent, but they can actually reiterate what the legislators said is or is not law as the case is brought about them. Through that and future going forward, ran across another very powerful 1995 case that was dealing with term limits. It's interesting how everything that's dealing with restricting the power of the government is getting overthrown by the system that controls the system. So it's like whenever they made the ruling in U.S. term limits versus Thornton of 95, the Supreme Court actually did a really good ruling on it, that the states are to divest from adding in any additional qualifications for state and for federal representatives and senators, and was very fine-tuned as far as saying only the Constitution is the qualification, the qualifications.
Right.
Which is that Article 1, Section 2 and 3.
So the additional qualifications could be considered, the primaries could be considered additional qualifications to run for a representative or senator at the national level.
It's common sense. Is the qualifying race an added qualification? Can you get to the general ballot? The constitutional ballot. Can you be on the constitutional ballot with the party that you believe and align with without passing a qualification race?
And you said a minute ago that you're not saying that primaries are evil or unnecessary, but you're saying that they should be contained within the party itself as a sort of an internal vetting process rather than part of the actual state-funded electoral process.
Absolutely. And I want to make this very clear. I absolutely love that there are two platforms that express their beliefs, ideologies, and practices. And I do believe in the First Amendment and the 14th Amendment with the right to assemble and associate. That each political party has the right, a First Amendment right, to be able to associate and nominate who they support, not place on. There's a difference. You can support a candidate and your PAC money and all the donor money for the candidate that the party has nominated, that this is the best view of our practices.
So I want to shift just a little bit here to the state of Oklahoma. That first case that I do want to come back to at some point. And I guess just to wrap up this conversation about the case that is being considered before the Supreme Court, it was your first case following your run for Senate. It's what made you look into primaries in general, look at some court precedent that was set in our nation's history, and conclude that the primary system in general is an additional qualifying process that is forbidden by courts and the Constitution. So where does this stand right now? This court case is being considered before the Supreme Court.
Yeah, we actually got notice on, I believe, January 17 that the Supreme Court received successfully and placed a docket number. Right now, we are waiting for the defendants to reply by February 17. So we have until February 17 for them to submit their response. And it should be pretty quick after that, probably within a month or two, that the Supreme Court will review all the booklets. And if they choose to respond, they'll be able to determine if they're going to put us on a docket for either oral hearing or just make a ruling showing the evidence that's in the booklet I sent.
Okay. And the defendants include Brian Bingman, Josh Cockcroft, he a former Secretary of State. Does that change now that we have a new Secretary of State?
Well, what the Supreme Court did is they actually put acting assistant attorney general on the docket as the defendant in this. This
Okay.
is following from when the case was originated through the appeals court. These were the defendants along the way. The acting assistant or Oklahoma attorney general will be on there as the defendants.
Okay. Okay. Paul Ziriax is also included here as the Oklahoma State Election Board director, and so we wait on their reply by February 17th. That's coming up, and then we'll see if you are given a date on the docket, Supreme Court docket. So that's pretty exciting, and I have to say, you've done all of this pro se, right? You are acting as your own attorney in this.
Yes, sir. That's been probably the challenging part, just making sure to research the cases and that they say what they say and putting the right parts where they need to be and just leaning on a higher source.
Yeah. Well, God does give us wisdom, and but the work you put into that is very admirable, and so I've got to give you recognition there. Let's shift the conversation to what's happening right here in the state with this other case. You, after filing this case that is now being considered by the Supreme Court of the United States, you filed a second one that deals more directly with State Question 836. So let's and we've talked about this briefly in a previous interview, but I don't assume that everyone has seen it. So let's review what this is in its original form, then we'll get to the appeal.
Yes, sir. State Question 836 is a scheme that is brought by three individual people, a independent Republican and a Democrat, with major contribution from Vote Yes 836. And we don't know where 836 is. As far as we know, it's Soros in a dummy account that's hidden under an attorney that filed for the nonprofit in the state of Oklahoma. We don't know where the NGO monies are coming from that they were able to mobilize and do what they did to spread out to get all these signatures for three individuals to be able to change a constitutional amendment, not just add a bill or a statute. The 836, there's some very vague language that is a open door of chaos, that only the top two are permitted after the qualification race to be on the general November election. When you look at top two, it's kind of like you mentioned earlier about Tulsa, where we had three top candidates that all scored over 30 points of the votes. Two were the Democrats that had the highest votes and a Republican that had the third highest votes.
Right.
In that sense,
you're over in the Tulsa area, so you actually were right in the middle of that.
Correct. Yeah, and that's the thing, is that I think people did show up more than they usually do. However, when you have a top two system or a scheme that eliminates regardless of party affiliation, and that's the wording in it, is regardless of party affiliation, it gives ample room for, let's just say, not a true clean election.
Yeah. So I want to make sure that people are not confused here, because it's not that you are supporting the agenda of 836, but you're approaching primaries from a completely different perspective.
Absolutely.
Yeah. So go ahead.
Yeah. The reason behind 836 is to muddy up how Oklahoma has done it for a long time. Right now, we are seeking to remain the status quo for election integrity and the best election that we could possibly have for the state of Oklahoma. The mechanism that they are trying to implement is attaching to the Constitution, which is almost nearly impossible to unwind once it is done. And that's why it's in the federal district court and now in the Court of Appeals, is because it's not a normal statute or a normal law that's gone through the legislature. They have figured out that there is a way to bring three individuals together, get enough signatures, and the governor can do a special election with this ballot initiative before the primaries, and we wake up on the primary day and everything's changed.
And you're talking about this upcoming primary.
Yes, sir. Yeah, because the governor has special election power, and that's one of the reasons, like in 2023, I'm sorry, not 2013, 2023 in March, there was a special election for a ballot initiative that I never knew about because it wasn't advertised like a general or primary election. That's how they pass these monumental changes that keep us bound by government power.
So you filed this original suit, and the defendants here include Benjamin LePack in his official capacity as acting Oklahoma Secretary of State and the Oklahoma State Election Board.
Yes, sir.
And what is the call in a concise way so all of our listeners and viewers can understand what is it that this seeks to accomplish?
This seeks to accomplish that the election machinery, which has the power to halt a unconstitutional act from performing or continuing. We are seeking a cease and desist order from the Secretary of State's office from further certification, verification, or ballot placement, as well as the Oklahoma State Election Board from proceeding with something that will change the Constitution of Oklahoma that later will most likely be unlawful or unconstitutional.
Because like you said, if this were to succeed and we have a true constitutional change regarding elections in Oklahoma, and I don't think that this was clear in the petitioners out in front of Walmart and all the various stores saying that this is a constitutional change to our election process in Oklahoma. I'm sure that the majority of people signing this weren't made aware of that, how significant this is. Maybe they were, but I personally was never approached by a petitioner to sign. But I have been very vocal about decline to sign. This is not good for Oklahoma. But this is a true constitutional change of our election process, which would be very difficult to unwind, like you said. And the court has initially rejected this based on standing. Is that correct? Saying that that they would have to wait until the process is complete before you have an opportunity to challenge it. And your argument is once it's complete, good luck challenging it.
Right. Yeah, and that's the standing, as well as they're calling on a old 1896 lawsuit in the Supreme Court that halts or stops the enjoyment of core equities with legislative action. However, this is not legislative action. This is a election machinery executive steps that are proceeding actively, leading to a constitutional injury that's not yet performed. Now, one of the things, and this is something
just to be clear, you're essentially saying that the court is saying they can't get involved in a legislative process that has to do with laws. They have to let the legislative process work its way out, and then after the fact, they can step in and rule as to its constitutionality of whether or not this is legitimate or not. But your argument is this does not involve actually the legislature or the legislative process. This involves a ballot initiative that is directly to the people. This is not the court involving itself in the legislative process and overstepping its boundaries. This is actually a very different process, the ballot process, initiative petition process, where the court can step in interject itself and shut this down before it moves any further. Is that a good summary?
That's a pretty good summary, because a lot of it, they're taking it as if I'm trying to have them put opinion into legislation, and we're not. What we are
But we don't
doing,
want that.
yeah,
We don't
no,
want that.
yeah, and not only that, but this case is completely different because one, it's not going through the legislature the typical way a statute or legislation. And the original 1896 case, from what I can understand of it, is dealing with how a waterworks company was trying to impede a municipal ordinance that would have affected the waterworks company, and that's where that bad ruling came from. It's not necessarily a bad ruling; it's just an abused blanket bar ruling. So they use that whenever they can to halt or dismiss a case. What we are doing is calling out and exposing that the 14th Amendment says no state shall make or enforce any law that abridges rights of the United States citizen. Now, you got to understand in the 14th Amendment, the word make is a future prohibitory terminology. And one of the things that the courts are deciding is they're turning make into made, a past tense part, not a verb that is actively in process. And one of the things that we called out is part of the Black's Law, which is originally the law that came over whenever we created our judicial and our constitution and how we have our legislation. Part of that definition of make is encompasses the formal steps by which a law is brought into existence, not merely a completed enactment. That alone should tell the court that you can't just bar it because it's not made already. The law, Black's Law, which is the foundational law of their law system, says that it's not a completed enactment.
Yeah, so important. And, that is right here on the first page of your appeal. You state the Article 1, Section 4, Clause 1, and the Supremacy Clause, Article 6, Clause 2 of the Federal Constitution. And the 14th Amendment states, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. And so your argument is that this allows for the court to intervene before it's finalized.
Right. It's required because they are concrete steps to a unconstitutional ends, and they're prohibited from doing that.
Right. So it's not just that this allows for it, it requires them to step in. And if this is on a path that would violate the Constitution or the rights of the citizens, then it is the court's responsibility to step in before it's finalized.
Correct.
So good. And I mean, like I said in the beginning, right now, this doesn't have to depend on the outcome of the ballot. That the attempt is, let's shut this down before it gets to the ballot. Now, since they have collected the signatures, they collected the 200,000 signatures, and this is moving towards a vote of the people, which we've already seen a pattern here in Oklahoma, with the adoption of medical marijuana in the state without regulation, without any kind of infrastructure set up, which allowed for it to be the wild, wild west and foreign ownership of land and the intrusion of China and Russia and all these foreign actors. So it was a bad thing. I'm not opposed to medical marijuana, by the way. I think it has a lot of benefits, but it needs the proper guardrails and regulations and things like that. But the way it went about, it went straight to the vote of the people before any infrastructure was set up. And it was a mess, and we're still cleaning up that mess. And we probably will be cleaning up that mess for years to come. But there was that. And then we had, of course, the Medicaid expansion, which I feel was detrimental to our healthcare system here in the state of Oklahoma. And so don't assume that we're safe. They've got the signatures. It's headed towards a ballot, a vote of the people. And I would say most likely this would pass based on the general ignorance of our population and how this is being portrayed, how it's being, the messaging connected to this. So I'm very concerned about it and how this literally changes Oklahoma overnight. This could flip it to a blue state leadership very quickly. So this could be our last best hope is your work, Adam. So I thank you for this. And they have rejected your initial appeal or your initial case. You have appealed it. This is currently in the appeals process. And the appeal is, first, let's just recap why they rejected it, saying that you have to wait for this process to play out for it to become finalized before they can take action. Your argument in the appeal is, no, you don't. In fact, you're required to step in before it is finalized and the injury actually occurs.
Correct. And that's the thing is that Article 6, Clause 2, the Constitution is a supreme law of the land, and it even has a specific part of the Article 6, Clause 2 that speaks to the judges that they cannot enforce or notwithstanding if it violates the Constitution itself, the judges are required to overthrow it.
Yeah. I'm looking here at page 6. Let's see. It says whether the district court erred in holding the plaintiff lacked Article 3 standing and that the claims were unripe because State Question 836 had not yet been approved and enforced, where plaintiff challenged ongoing time-bound executive administration of Oklahoma's initiative and election machinery, moving State Question 836 toward verification, certification, and ballot placement. And it goes on to expound on that. And I know for those listening that the legal jargon and terminology can lose you pretty quickly. Once you start reading it, you get more accustomed to it. But this is where a lot of people check out when they start hearing all the legal jargon, and it's too overwhelming. So we have to make this plain for the people to understand. And it's not to say that the people are ignorant. It's just a way that it is presented and laid out that can become cumbersome.
Yeah, it's Greek unless if you get exposure to it.
Yes, exactly. So highlight in here the key points that we need to bring to the attention of the people. And as we're doing that too, are the people able to download this document to view it themselves? Is this available to the public?
Yes, sir. One of the things I am a very big stickler on is transparency. That's one of the reasons why on my website, adamforoklahoma.com, you can, on the homepage, you can click either the primary election button or the Oklahoma SQ 836 button, and you can go and open and download each of the documents that I've applied there for you. On the Oklahoma SQ 836, there should be 4 documents. The bottom document you can open, and it's this very motion to appeal that was approved in the 10th Circuit Appeals Court.
Okay, wonderful. I'm going to make sure that we put that here on the show as well. So
yeah, while you're doing that, there's actually in the 10th Circuit Appeals Court where we're at now. Back in 2012, Oklahoma had a ban Sharia law initiative on a ballot that actually got the votes and everything. And one of the things that I'm calling out in this is that case Awad versus Paul Zurich of 2012, because it dealt with a First Amendment violation that they deemed as a violation of his rights or of all Muslim rights in that aspect. And so if you look at it, they already have their own precedent and their own ruling saying that if it violates the First Amendment, as far as association, and that's what religion is a right to association and to perform it the way that you do. Political parties are no different. We have a right to association and ensure that the candidates that our party and our ideologies agree with are not monkeyed with, say, people from an opposing party deliberately coming and getting the weakest candidate out there so they can win with their strongest candidate. And that's what
Yeah,
the
it's a
top.
great point. I mean, we've been talking about this case in this this conversation about Sharia law, and of course, we have a House Joint Resolution that's been proposed in the House this year to ban Sharia law, and it is recalling this previous case in 2010. And so, such a great point. We already have court precedent where they stepped in before it was finalized, correct? With this Sharia law ban.
Yeah, it was actually they were counting the ballots. I believe it actually got to the point of being voted on, if I remember correctly. I may be wrong on
No,
that.
no, I think they did. It came to a vote of the people.
And they got it banned even when the people voted for it.
So then, to play devil's advocate here, does that precedent favor the ruling of the court here, in that it needs to be finalized?
No. What it shows is they brought suit because they got the votes passed. So whenever you're looking at it, they may go ahead and get it close to the ballot before the appeals court makes a ruling. But that's why we have to start action now, because we can't wait until, for example, Governor Stitt has the government power to put this to a special election before our primaries and fundamentally change how we do this midterm.
Do you think that's a likely possibility that the governor would do that?
95%. Okay.
That if state question 836 goes to a vote of the people, and is that what you're talking about? The special election for 836?
Yep.
Okay. So that's what we want to avoid, is a call for a special election prior to the upcoming primaries that would solidify 836, institute the constitutional change here in the state, change the election process forever. You say forever. I mean, it could be fought, but that's a long, lengthy process that's very hard to undo, like you already said. But possibility of a special election to finalize 836, change our primary election process, and change the demographic, the political landscape of Oklahoma almost overnight. So very concerning. Adam, I want to make sure that you have said everything you feel like you need to say on this case, and then I want to follow up with how people can take action and get behind this. I think this is something that the Oklahoma Republican Party should be behind. I don't know if you've had a chance to have conversation with leadership with the Oklahoma Republican Party, but I think that would be something that they would be very interested in, just from my perspective.
Oh, absolutely. And I'm excited to see how involved they do choose to take one of their affiliated voters and back a really good initiative, to see how they really stand up for Oklahoma, even when it's an individual voter standing up first.
Absolutely. And, again, both cases, you have been working on this pro se, doing all of the legwork and research and filing yourself, making the trip, I'm guessing, from Tulsa to Oklahoma City to file. And that can be a very tedious process. And, of course, on your own dime. So how can we help with that? How can the people help with that? Or is there a need for, would you want an attorney to step in and assist with this? Or do you want to continue this on your own?
I believe a lot of it is, we are now in the appeals court. If there are attorneys that would like to represent the Oklahoma GOP or the RNC in this, that would like to attach and be a friend of the court and join the case, backing one of their registered voters, then I think that would add so much power and influence to the court, that should they stand up and say, hey, this is right. This is violating. Whereas before, the attorneys were representing the Oklahoma GOP based on associational rights of the First and 14th Amendment. What I have been revealed is that we're taking the 14th Amendment as primary, that they cannot make the law in the first place, and that wasn't approached in the first time.
So, if there's a good constitutional attorney out there who believes in this cause, and you want to jump on this and come alongside the Oklahoma GOP, the RNC, and become a friend of the court, essentially putting their name on this alongside yours, saying
Correct.
that they also support this cause and this action, that would be helpful. As the court here in the state of Oklahoma, this is let me look here, the Western District, right?
Correct.
Western District Court. So the Western District Court would see that there is growing in support for this cause, and it just gives more credibility and weight to this appeal. So again, if there's an Oklahoma constitutional attorney out there, there's a call for you. We need your help in this. It'd be good to have your support to come alongside the Oklahoma GOP. If the GOP wants to get involved in this, I'm just making assumptions here, but I think it would be good. It seems good from my perspective for them to jump on this. This is actually a fight for the life of the GOP here in Oklahoma. So I think it would it makes sense for them to jump on and then have a constitutional attorney to jump on. I would assume even pro bono, because the Oklahoma GOP is overcoming this past debt they're working on paying off, and doing a great job, by the way, doing that. But it would be helpful for a pro bono constitutional attorney to jump in and help them with this and help this cause. Adam, again, I just so appreciate your work in this and appreciate you coming on this morning to lay this out. Again, I have it scrolling at the bottom, adamforoklahoma.com. People can go there to find out more about you, and also to download this document that shows what it is we're working on. So go there. Is there anything else we can do as far as helping financially, or showing up at court, or writing a letter, or signing a petition? Are there any of those kinds of actions?
There are a couple of things that would be helpful in this time. On the website, adamforoklahoma.com, up at the top, you can donate, and it goes to a GoFundMe. Sorry, it's GoFundMe. That's the only one that I know of right now to to do, right? But you can contribute financially, pray about it, see what you can do that would help a lot of the out-of-pocket costs that we've been having to do, especially with both cases going on now. Thankfully,
and by we you mean you and your wife.
Yes, and I'm very grateful for my beautiful wife Crystal, because she's backed me 100% on this, and even when it's put our finances in not so fun of a situation.
Yeah, I mean, hey, and this is that personal sacrifice that often people avoid, but that is required. It is required for the fight. And, people wait until it's easy. We can't wait until it's easy, or you're ready, or you have enough money, because by that time you've lost your freedom.
Right,
And so
that's where it's like the only thing necessary for evil to prevail is good men to do nothing, and I could not just sit back and do nothing when I walked through the first case, got up through the 10th Circuit Appeals Court. I was hoping we wouldn't have to go to the appeals court with the second case, with the state question 836. But it's almost like I was trained to get the formats right and everything to be able to get a successful appeals court. And to be in the same court that they already ruled on a First Amendment with Awad versus Paul Zurich. So we have a great opportunity that the same court with the same justices will see no difference, that that's a violation of the rights of the political parties or a political faith.
I so appreciate your work in this, Adam. And we'll be praying for you and your wife and this whole process. I mean, we here in Oklahoma should be very interested and concerned with what's happening here. And most people, unfortunately, are ignorant to what's actually unfolding. But it is quickly approaching the cliff and the point of no return. So this is an opportunity to turn this thing before it goes over the cliff. And I'm behind it. I encourage people to get behind it. I appreciate your work and appreciate your time this morning to bring more attention to it. And as we get information on this case going before the Supreme Court, hopefully, we'll maybe after February 17th, after these defendants reply, we can come back on and talk about where this stands now, or then at that point. But Adam, any final words?
Yes, and thank you very much for providing a platform for we the people, the grassroots people, to be able to stand up and speak and have the opportunity to reach people we would not on our own. To trust in the establishment's media sources to get a message like this out would be throwing a penny in a wishing well, so to speak. So the importance too is to try to get everybody to share this video. Social media has made a big difference since 2016 in getting non-establishment people in office, and we have 47 in there now because of it, right? The other thing too is to keep in mind that, like Hosea 4:6 says, "My people perish for lack of knowledge." Become hungry for the Constitution and learning what it means and how it does, because even Samuel Adams in 1776 wrote to John Pitts in a letter in January that how strangely the tools of a tyrant pervert the plain meaning of words. And what we are attacking and what we are tearing down by doing these cases is giving revelation to the words that were perverted in order to enslave.
How strangely the tools of a tyrant pervert the plain meaning of words. And this is something I think that we've brought a lot of attention to and have seen occur over especially the last few years, with the twisting of words and making them mean something else.
Like, what is a woman?
What is a woman? Exactly. Case in point. Adam, thank you, brother. We'll be praying for you. We'll be giving to this cause. And again, adamforoklahoma.com. Go check it out, get behind it. And we'll be praying for the state of Oklahoma in this whole process.
And if the viewers will reach out to the Oklahoma GOP and the RNC and ask them to join and be part of this case to help back it, that'd be awesome.
That'd be great. Yeah, absolutely. And I'll tag them in this. And like you said, if everyone could just share this video, it's coming up on an hour. It's a longer video, but it's a long discussion. It's a needed discussion. So share it, and hopefully people will watch at least some of it, part of it, most of it, and get educated and understand what is required of them in this day. So I appreciate all of you guys listening. Be sure to like, share, and subscribe over on YouTube. That helps get the algorithm open, and you'll get a notice every time we have a new episode released. So appreciate you guys tuning in. God bless you guys. Have an amazing day. God bless you, Adam.
God bless you, Jake.